good. Okay, welcome back to the second session of the symposium today on Roe at 40. Our second panel will speak, each of them, for 15 minutes, and then at the end of that, we will have questions for the remainder of the time. Right now, we have 3 out of our 4 speakers, so the order of presentations will be slightly different from that in the schedule. First, we will have Professor Richard Myers from Ave Maria School of Law speaking on rereading Roe versus Wade. Second, we will have Priscilla Smith, scholar and fellow at the Information Society Project at Yale Law School. And she will be speaking on the purpose of Casey's purpose prong, protecting women's equal right to liberty. And third, we have Professor Tom Molony from Elon University School of Law, and he will be speaking on Roe, Casey, and same-sex selection abortion bans. Thank you. Professor Myers.
Thanks so much. It's a great pleasure to be here, and I want to thank Sam Calhoun for all of his work in putting this together, and also the folks from the Washington Lee Law Review who have been just amazing in all their organizational efforts and their hospitality, and just a great pleasure to be here. In January 2013, Linda Greenhouse published a comment in the New York Times marking the 40th anniversary of Roe, and in the course of that comment, she made the point that almost no one ever reads the court's decision in Roe against Wade. And I think there's a lot of truth to that. That may not be true in this room, but I think in general there's a lot of truth to that. Roe's really become a symbol. It was a great victory for women's rights. It was an important part of a cultural transformation. It's perhaps the leading example of judicial excess. It's the manifestation of the culture of death. But I think it's true that people don't actually read the decision very much anymore. And after reading her comment, I did reread the opinion carefully, and I thought that was really a valuable experience, and I commend that to all of you. I think scholars, and this is not just pro-life scholars, know that the opinion is deeply flawed, but rereading the opinion from a perspective of 40 years makes that even more apparent. Yet I came away from rereading the opinion with a renewed confidence that the decision will ultimately be overturned. I'll make a few observations about the opinion. Most of the defects in Roe were apparent from the very beginning and were explored in critical articles that were written in the immediate aftermath of the decision by people like John Hart Ely and Richard Epstein and many others. But some of these well-known errors, I think, are still notable on a fresh read. And I'll talk about some weaknesses. I think in rereading it is just striking how poor the opinion is at so many levels. And so maybe it's not Harry Blackman that deserves the blame, maybe it's his law clerk. But it really is poor at so many levels. I'm going to just discuss some of the more obvious examples. First, the court's treatment of substantive due process was really shockingly weak. The court had rejected all substantive review under the Due Process Clause as recently as 1963. Griswold, mentioned earlier, didn't actually endorse the doctrine. The court was avoiding relying upon it. And in Roe, the court did forthrightly accept the doctrine of substantive due process, but it was really almost casual. The court didn't bother to explain at all why the Due Process Clause had a substantive component. Even if one accepted the doctrine of substantive due process, the court's explanation for why the choice of an abortion is protected as a fundamental liberty was almost non-existent. The court, without a hint of irony, even invoked Justice Holmes' dissent in Lochner, in which Holmes noted the need for judicial restraint. As John Ely noted, in the end, the court simply announces that the right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The second weakness I want to mention just briefly is the court's treatment of the history of abortion. I think it's pretty clear to everyone who's looked at it with any care that that part of the opinion is just an embarrassment. The treatment seemed designed to show that there had been some sort of a historical recognition of the right to an abortion in American law, but that's, I think, been refuted by many scholars over the years. John Keown at Georgetown stated Roe was a radical break with the law's historical protection of the unborn child, and thereby with its adherence to the principle of the inviolability of human life. Roe's invention, this is Keown again, of a constitutional right to abortion represented a radical rejection of America's long-standing history and traditions. The third weakness relates to how the court treated the protection for the unborn in other areas of the law. And I think that part of the opinion was also fundamentally flawed. An accurate account of how the unborn were treated in other areas of the law would have undermined the court's conclusions. Moreover, the court ignored the fact that, as Richard Epstein noted, that recent judicial trends have expanded, not limited, the rights of the unborn. Fourth, the court's treatment of the personhood issue, which came up briefly in the last session, was also incredibly weak. And I think the easiest way to understand that is to compare Justice Blackmun's opinion with the recent 70-page article written by Michael Paulson, sitting over there. That article is entitled "The Plausibility of Personhood." So he doesn't argue that the relevant materials compel the conclusion that the unborn should be regarded as a person, but he makes the argument that it's certainly a plausible case. He concludes the clear plausibility of personhood suggests, at the very least, that Roe, on this point, as on so many others, is indefensible. The fifth weakness relates to how the court treated the origins and value of human life. The court said, and this came up in one of the questions, that they didn't need to decide the issue of when life begins. Yet I think that was a false gesture of humility. The court did decide the issue because the court necessarily rejected the legislative judgment that fetal life deserves protection. In the court's judgment, the unborn did not have any interest that the mother or the state was bound to respect. The second aspect that I wanted to focus on is, this has also come up in the questions, was the court's neglect of the consideration of Roe as a women's rights issue. And that was a point that Greenhouse made in her comment back in January in the New York Times. And I think people have commented on that quite a bit, but when you go back and read the opinion, it's really shocking. There's no women's right at all. It's totally a doctor's judgment. The court's summary of the holding ignored the women's interest almost entirely. The court said in the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. After viability, the abortion decision is again assigned to appropriate medical judgment. And I think the errors in that thinking are obvious. Richard Epstein noted this was immediately after the decision. The court's conclusion doesn't seem a fair implication of the right of privacy. Nobody was talking about the doctor's right of privacy because that would have certainly not been regarded as a fundamental right after the Lochner era. And that was really the basis for the decision, was privacy. The privacy protected, Epstein noted, is that of the pregnant woman and not the attending physician. Moreover, Epstein continued, it's either pretense or folly to assume that the decision to have an abortion will be made for the most part by physicians on the basis of their best medical judgment. In nearly every instance, there's no medical question and hence no place for medical judgment. The third aspect of the decision that I thought was notable on a reread were the eugenic comments in Blackmun's opinion. In one of the earliest sentences in the opinion, Justice Blackmun noted that population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. His conclusion emphasized that the court's holding was consistent with the demands of the profound problems of the present day. And he certainly wasn't endorsing the ugly eugenic history of the demand for abortion rights, but I think rereading those comments was instructive. That issue resurfaced a couple of years ago when Justice Ginsburg made some comments that reflected the same sort of thinking. Justice Ginsburg, this was in an interview with Emily Bazelon in 2009, said, "Frankly, I had thought that at the time Roe was decided, there was concern about population growth, and particularly growth in populations that we don't want to have too many of." Justice Ginsburg's comments created a firestorm, and 3 years later, that seemed like kind of an oddity to me, that there was major controversy about the implications of her comments, and then she had another interview 3 years later. So it seems like if you were going to correct the record, you might not have waited 3 years. And if you read the comments in the 2012 interview, they do absolutely nothing to allay the concerns people had about her original comments. I think and we could go into that if you'd like, but I think it didn't allay any of the concerns. I think that the eugenics aspects of the issue are really complicated, but I think that it's a revealing aspect of the decision. eugenics is a complicated movement, but it typically involves efforts to improve the human species and often involves efforts to eliminate the unfit. It's worth recalling Justice Holmes' statement from Buck against Bell, his enthusiastic comment that 3 generations of imbeciles are enough. The eugenics efforts typically carry with them a rejection of the idea that human beings have equal dignity. They reject the traditional sanctity of life ethic and focus rather on the quality of life. That's why I think some of the further comments in Blackmun's opinion were also alarming. Justice Blackmun stated when discussing the personhood that the unborn have never been regarded as persons in the whole sense. He later commented when discussing viability that that was the point at which the fetus then presumably has the capability of meaningful life outside the mother's womb. And I think those comments further supported the charge that the court was implicitly adopting a quality of life orientation. So some of the lessons, I think, from a rereading of Roe. I think if you reread the opinion, one of the strongest impressions one gets is that it's an incredibly weak opinion. I think that was well understood from the beginning, but I think it's even more striking on a fresh reading of the opinion 40 years later. I think that's an important reason for believing that Roe will ultimately be overturned. The judicial rationale for a nearly unlimited right to an abortion was deeply flawed from the outset, and that's become clear with the passage of years. Advocates for the right to an abortion have been rewriting the opinion, so there's kind of a cottage industry of rewriting Roe against Wade, but I think it's illuminating that those efforts have really have floundered over the years, and that too, the realization that no one alternative explanation has really taken hold suggests that Roe will eventually be overturned. The other aspect that relates in part to the weakness of the opinion is that there's still a continuing controversy about Roe, and this conference is just one example. I think that it's worth reflecting on how unusual that is. The fact that 40 years later there's ongoing critique and reevaluation of Roe is really stunning. I think in other areas of the law we don't really encounter that same sort of effort to critique decisions that are in theory settled law. So for example, the sex discrimination decisions of the Berger Court in the early and mid-70s, precisely the time of Roe, were enormously controversial. Those decisions made significant changes in equal protection law. The court elevated the level of scrutiny it used in sex discrimination cases. And those decisions were accused by some, and still occasionally today, were criticized as examples of judicial activism. There wasn't much support for the court's approach in the text or the history or prior judicial interpretation of the Equal Protection Clause. Those decisions, like the abortion case, came at a time of sweeping cultural changes on matters of sexual equality. Yet today there's almost no controversy about those decisions. They're widely accepted. What's often called the de facto ERA is widely accepted as a matter of constitutional law. No one holds conferences reassessing Craig against Boren. And I think the contrast with Roe against Wade couldn't be more striking. Roe was controversial in 1973, and it's still controversial. In addition to the withering critiques of the opinion as an exercise of constitutional interpretation, there's the profoundly significant matter that Roe has not been accepted in the broader culture. There's constant resistance to Roe among judges, legislators, academics, and in the broader culture. I think that the public opinion indicates that that Roe and Casey are not sufficiently well accepted to remove the issue from broader public debate. No one thinks that the court's approach to sex discrimination reflected in Craig against Boren hangs by a thread, yet nearly 40 years after Roe, that notion that Roe hangs by a thread is a reasonable, although contested, assessment. The other thing that struck me about Roe is that in reality, I don't think the decision is the landmark that its reputation would seem to suggest. Roe was, in many respects, a momentous decision. It's had enormous impact in opening the door to a staggering number of abortions over the last 50 years. Of course, many of those abortions would have happened without Roe, but I think it's important and tragic that those abortions have occurred with the imprimatur of the Supreme Court. But Roe always seemed to be much more than that. The opinion has been viewed as an exemplar of an approach to judicial decision-making, but in reality, the decision is really an outlier. If you look at other areas of the law, Clark Forsyth mentioned this earlier, the unborn have increasingly been accorded legal protection. The Federal Unborn Victims of Violence Act and various state counterparts, the Federal Born Alive Infants Protection Act are two examples. Roe has become increasingly isolated on that point, as on many others. I think that's also true with regard to substantive due process. Roe is, in certain respects, an outlier. The court rejected or adopted an approach to substantive due process in the assisted suicide cases, Washington against Glucksberg and Vacco against Quill, and the approach to substantive due process in those cases amounted to a rejection of the approach the court had used in Roe and would lead, I think most people say, to the reversal of the decisions. So and I think Glucksberg is still the leading case on substantive due process. So Roe, I think, is an outlier on that issue, and it hasn't really been followed in subsequent cases with Casey is reaffirming Roe, but in other cases it hasn't really been followed. I think I'm going to stop there about at the end of time. So, thank you.
Okay, thanks. So I didn't come here today to defend Roe, although I do give a talk on that sometimes, and if you'd like to invite me back, I'd be happy to come. Because I find none of what I've heard so far persuasive. And in fact, these are arguments that have been made since Roe and rejected again and again since Roe. But in the interest of the spirit of this conference, I've decided to talk about Casey, which is the law of today, not Roe. So these continuing controversies and questions about Roe, which I would refute if I had the hour to do it, that I like to do, I will leave aside because the real issue today is Casey. Casey is the law of the land, not Roe. I can't help but just point out the irony of criticisms of Roe for not being feminist enough, which are criticisms that feminists make about Roe, that Roe doesn't talk enough about the woman and about her experience of pregnancy and her interests in the right to abortion. But I find it ironic to hear those criticisms leveled against Roe in a way that's meant to undermine Roe and the right to abortion altogether. So I just felt I needed to say that. But so let's go to Casey. I'm going to talk about three things. I'm going to try to do it really fast. Okay. I'm going to talk about Casey's compromise. What was it? I'm going to talk about the role that the purpose prong in the undue burden standard in Casey plays in maintaining that compromise. And I'm going to end with some thoughts about current controversies, because I understand that to be what this panel is about. Okay. So on the one hand, what did Casey do? What was the compromise? Casey gave some things to the pro-life community. And what it did was increase the state's ability to regulate abortion in furtherance of the interest in potential life, an interest that the three judges in the plurality in Casey felt had been disregarded by the court in previous decisions. It did this by discarding the trimester framework that you've heard criticized, a framework that I, in my hour-long presentation, would talk about at great length and tell you why I think it makes sense in terms of biology of pregnancy and abortion procedures. But I'm not doing that today. The second thing, the way that Casey increased the state's interest in potential life, it allowed states for the first time to take a position on abortion, to inject itself in an otherwise private contractual arrangement between the patient and the doctor, and by requiring doctors to give women certain information that was designed to dissuade them from having the abortion. It could require the doctor to say this to women. it seemed to allow states to require doctors to give information that they would not normally give women if they followed real informed consent standards, medical standards for informed consent, standards that apply to all other medical care. Right? Okay. The new test the court adopted was this undue burden standard you probably all have read about in con law at some point or another, which allowed regulations as long as they did not have the purpose or the effect of imposing an undue burden on a woman's ability to obtain abortion. And an undue burden was further defined to mean a substantial obstacle in the path of obtaining an abortion. Both of those terms are as vague as you think they are. They are heavily litigated. They're the source of great controversy, which we won't address today. In upholding Pennsylvania's mandatory information requirements, the court placed 2 limits on the information doctors could be required to give, and these were important limits in the court's view. They limited the information to information designed to inform a woman's choice, not hinder it. They limited the information to information that is truthful and not misleading. On the other hand, Casey gave pro-choice advocates something as well. First, it recognized that it's not only anti-abortion, pro-life people who hold their positions as a matter of conscience. It recognized that people who are pro-choice also have beliefs that are in line with their conscience and their religious or moral codes, and in fact that the decision itself to have an abortion, it originates within the zone of conscience and belief. And this, I think, is an overlooked and fundamental part of that Casey decision. It recognizes, and it talks about this at some length, the fact that the decision is infused not just with a woman's sense of self and autonomy, the right to define the course of one's life, self-definition, etc., language the court then goes on to reference in Lawrence versus Texas, also a substantive due process decision by the court striking down the Texas sodomy law, but also that the decision is infused with our notion of what it means to parent, how to parent, what it means to create life, to create family, and what our responsibility is for any life we do create and bring into the world. And that those issues are matters of conscience that women consider when they decide whether or not to have an abortion. Okay. The second thing the court did for pro-choice people in Casey was to recognize for the first time the importance of the right to abortion to women's equality. And it did this in 2 ways. It reaffirmed Roe in part based on its recognition that the ability of women, quote unquote, to participate equally in the economic and social life of the nation has been facilitated by women's ability to control their reproductive lives. That's the quote you probably have heard most often when you hear about notions of equality in the Casey opinion. But it also recognized that anti-abortion regulations sometimes channel subordinating views of women, stereotyped views of women and their roles in society and families. And Casey's plurality recognized this in the manner in which it struck down the spousal notification provision. It struck it down both because it had the effect of placing a substantial obstacle in the path of women obtaining abortions. In a large fraction of the cases in which the spousal notice provision is relevant, it will operate as a substantial obstacle to a woman's choice to undergo the abortion. But it also, the court of the plurality rather, also recognized that the notice provision had an invalid purpose. It embodied a view of marriage consonant with the common law status of women, but repugnant to our present understanding of marriage and of the nature of rights secured in the Constitution. So Casey is recognizing an equality protective aspect of the right to liberty that protects the right to abortion. Okay? This recognition of the equality aspect of the right to liberty, that women have an equal right to liberty this notion that the 14th Amendment rights act together in concert can be traced back in the cases and has been referred to in scholarship, if you want to look it up, to a stereoscopic notion of rights or to hybrid rights. And we can see this in the old contraception cases from Griswold to Eisenstadt, in Skinner, where the right to procreation is recognized in an equal protection case, in Brown versus Board of Education, in Loving versus Virginia. The notion of an equal right to liberty shows up in Blackmun's opinion in Thornburg. And at least since the 19th Amendment, women have had an equal right to liberty. But the problem in equality doctrine has always been, both in sex discrimination doctrine as well as in race and other areas, that we're still figuring out what it means for people who were previously subordinated to be equal in society. We're still figuring out what it means for women to be equal to men. And it's always taken this country a long time to figure this out, to figure out what true equality means and to overcome a history of discrimination against groups of people by political viewpoint, by religion, by race, by sex, by sexual orientation. Aha! In fact, it took a long time for our society to acknowledge that bans on interracial marriage were discriminatory. Some argued that these bans were equal because neither race was allowed to marry outside of your race. You know, white people can't marry black people, but black people can't marry white people, and so it's equal. Right. It was only after people revealed the discriminatory belief system behind this view, that this view masks hierarchical views of the status of people of different races, that people understood that these bans were violating equality principles. So judicial scrutiny of government regulations designed to ensure the constitutional guarantee of equality, whether under the Equal Protection Clause or the First Amendment, all must ensure that laws that appear neutral on their face are not acting unconstitutionally, to ensure that claims of the state interest being advocated are not pretextual claims to allow the state to establish or reinforce conditions of inequality. And judicial review must be designed, as the scholars used to talk about it, to smoke out invidious intent, invidious purpose which is designed to enforce subordinated status, the subordinated status of disfavored groups. The question is, under Casey, how did the court intend to protect against invalid intent and subordinating purpose? Under Roe, it was clear what state interests could track and could justify which types of regulations, because the trimester framework made that clear. Once we had Casey, it was less well understood where the state interest inquiry was meant to go. But it's my contention that it's in the purpose prong, and we can see that operate in Gonzalez versus Carhart, where the court evaluated the validity of state interests doing a purpose inquiry. And they did this even though the plaintiffs, we had not made a purpose prong claim at all in that case. But they went to great lengths, Justice Kennedy went to great lengths to evaluate the purpose of the statutes and to determine if there was a valid purpose for the ban on what was called partial birth abortion in that case. The court's recent decision striking down the Federal Defense of Marriage Act in United States versus Windsor has further anchored a purpose analysis to judicial review of government infringements on the right to liberty, especially where these equality interests are at stake. And the court talks in Windsor about an equal right to liberty. And in determining whether that equal right to liberty had been violated, the court carefully examined the claimed state interest supporting DOMA and held no legitimate purpose overcomes the purpose and effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. Now, I only have 2 minutes left to talk about how this works in current controversies. Maybe we'll get into this more in our question and answer period. But what I was going to do was talk about how this applies in the context of bans on medical abortion, which almost went to the Supreme Court in the Klein case out of Oklahoma, but which the Supreme Court decided to dismiss their grant of cert as improvidently granted for a number of reasons having to do with the scope of the law there. I think the court will eventually take up the issue in its narrower form. They will take up the question of whether states can restrict medical abortion to outdated medical protocol that has been shown through the gold standard of clinical trials to be less effective and to produce more side effects than newer protocol. And the court will then have to decide, what is the purpose of such a law? Is there any valid state interest to require doctors to perform bad medicine? And I think the answer will be and should be no. Thank you.
Thank you. Well, it's indeed a pleasure to be here. I spent 7 years here as a student at Washington and Lee, and it's really a great pleasure to return to Lexington. And I want to thank Sam Calhoun for his invitation, the Law Review, and for the other sponsors who have given us this opportunity to have a respectful dialogue about an issue that is really so very contentious. I will say that I speak with some trepidation today in front of my constitutional law professor, Ann Massey. You may, during the course of my talk, see her shaking her head, and she may be thinking, Molony never really did know constitutional law, which may be true. The debate about sex selection abortion, that is, abortion sought based on the sex of the fetus, is garnering attention across the globe. In England, where sex selection abortion is illegal, there's been a recent controversy swirling around the decision of the British Crown not to prosecute doctors who had agreed to perform illegal sex selection abortions. And in Australia, there is also a controversy surrounding a Catholic doctor who declined to perform a sex selection abortion and declined to refer it to someone else, and he's at risk of losing his medical license as a result of that. In the U.S. earlier this year, we've had 3 states that have adopted sex selection abortion bans: Kansas, North Dakota, and my home state of North Carolina. And those states have added to 4 existing states, Pennsylvania and Illinois, which have had bans for over 20 years now, and Arizona and Oklahoma, which have had more recent bans. There are other states that are considering legislation, or a number of other states considering legislation. And there are lots of good reasons that are cited for bans on sex selection abortion. One is experience in Asia with respect to sex selection abortion, where it is speculated that over 100 million women are missing as a result of male preference, and the accompanying effects of an imbalance in the sex ratio, resulting in increases in human trafficking and prostitution and violence. But in addition, there's also the concern just about treating women as lesser than, because sex selection abortion primarily affects women, affects female fetuses. And that runs contrary to what hopefully is becoming, and although it's been a long time coming, the accepted notion, or what ought to be accepted, that both men and women are of equal dignity. But of course, the question that we're talking about with respect to this conference, with respect to this symposium, is constitutionality. Are sex selection abortion bans constitutional? We can look back to the court in Roe, which of course is not the law now, in Casey is, but the court in Roe said, appellant and some amici argue that the woman's right is absolute and that she is entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason, she alone chooses. With this, we do not agree. Now, the court has addressed timing, Roe and Casey, and it's addressed the question of limitations on manner, Gonzalez. But it never has squarely faced the question of whether a state can limit abortion based on a woman's reasons for choosing abortion. But of course, Roe is no longer the law, Casey is. And although Casey retained Roe's essential holding, we now have a move away from the trimester framework to measures, looking at measures pre-viability and post-viability under two different standards. Now, sex selection abortion bans typically apply throughout pregnancy, so both pre-viability and post-viability, and they implicate both of Casey's standards. Many of them are narrow in scope, so they're limited in a lot of cases to prohibiting persons from performing an abortion when the person knows that the abortion is sought solely based on the sex of the fetus. Now, any type of ban is going to be suspect under Casey, and so I think it's important to look at the narrowest of sex selection abortion bans, the one that I just described. There are those that go farther, and North Carolina is probably the one that reaches out the farthest. And if you look at Casey, Casey seems to provide some easy answers. Post-viability, Casey says this: subsequent to viability of the state in promoting its interest in the potentiality of life may, if it chooses, regulate and even prescribe abortion, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. So with respect to sex selection abortion bans, easy answer is constitutional, so long as life and health exceptions are made, which they don't do. But I think the more interesting question, I still think they're okay, but I want to get into the question of pre-viability, because I think that's the more interesting question with respect to Casey and sex selection abortion bans. Casey says this: regardless of whether exceptions are made for particular circumstances, a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. So again, if we look at this statement, it seems to provide an easy answer. Sex selection abortion bans are unconstitutional pre-viability. End of story. I can sit down. I'm safely within the 15-minute allotment. But, and I think that recent cases do help to, or recent opinions with respect to fetal pain and fetal heartbeat statutes tend to reinforce this view. The Ninth Circuit recently said, as to an Arizona fetal pain statute, that all pre-viability bans are unconstitutional. We don't have to look at the undue burden test. It's per se unconstitutional. In addition, some of the lower court cases dealing with these fetal heartbeat and fetal pain statutes have applied the undue burden test but have reached the same per se rule. But sex selection abortion bans are different from fetal pain and fetal heartbeat statutes. And the reason is, well, there are a number of reasons. One is that they don't attempt to replace viability as the dividing line between when the state's rights are robust and when the women's rights are robust. Second, they don't focus so much on the fetus, whether the fetus has a heartbeat, whether the fetus can feel pain. Instead, they focus on the woman and her decisions for having an abortion, her reasons for having an abortion. And these sex selection abortion bans don't just find their basis in potential life, the state's interest in protecting potential life. Instead, there's an additional interest at play, and the interest is in eradicating sex discrimination. It's because of this additional interest that a reasonable argument can be made that even pre-viability, a sex selection abortion ban is constitutional. Nevertheless, it's hard to get around Casey's statement that a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. But if you look at Casey closely, and I don't think you actually need to squint real hard to try to find it. If you look at Casey closely, you can see that, in fact, the court allows a state to take the decision, the ultimate decision, out of certain women's hands. And that's through the parental consent provision that the court validated in Casey. The Pennsylvania statute required parental consent, but it also included a judicial bypass provision. So in order for a minor to have an abortion, she could either get parental consent, or if she could not, she could go to the court and she could argue that she was mature enough to make the decision herself, or that it was in her best interest. Well, if we look at that, if we look at the effect of that statute, we can see that certain women are not permitted to make this decision. Who are they? Minors whose parents do not consent, who the court has determined it's not in their best interest to have an abortion, and the court has determined they're not mature. So certain women, the court says that a state may not prohibit any woman from making the ultimate decision, and yet it allows the state to prevent certain women from making the ultimate decision. And we can ask ourselves why. Why is that? And I think it's pretty clear in cases prior to Casey state this, is because there's an additional interest at play. A state has an interest in protecting children. So Casey tells us, and Casey's treatment of the parental consent provision tells us a few things. One, it tells us that, yes, a pre-viability ban can be constitutional. It tells us when that might be, when there is an additional interest that is different from the interest that the court had considered in establishing the viability standard, the interest in protecting potential life, maintaining medical standards, and protecting women's health. When there is an additional interest at play, then a ban might be permitted. Unfortunately, however, the court in its undue burden test doesn't tell us how to balance the interests. How do we figure out whether a state's interest is of sufficient strength to allow for a ban? And in talking about the parental consent provision of the Pennsylvania law, the court really glosses over it and says, we've been over most of this ground before. They've dealt with all of this before. And in those prior opinions, they talked about the state's special interest in protecting children. Where sex discrimination is concerned, though, we can find a possible model for the court to use in considering balancing the state's interests against the woman's interest in the case of a pre-viability ban. And you can find it in an unlikely place. And it's in the jurisprudence with respect to freedom of association for expressive purposes. So the cases of Roberts versus United States Jaycees, and Rotary International versus Rotary Club of Duarte, and Boy Scouts v. Dale. In those cases, the court applies an undue burden-like test. It's a balancing test, a balance between the state's interest, and Justice Scalia says we're balancing the state's interest on one side of the scale and then the rights of association on the other side. And in the cases of Roberts and Duarte, the court found that with respect to a public accommodation statute, that it was permissible for that statute to infringe on associational rights because it was supported by a compelling interest of the highest order of eradicating sex discrimination. And I think we can see this same interest present in the case of sex selection abortion bans. But it's not the only additional interest that's present. And we can see an additional interest that I don't know that the majority wanted to own up to in Gonzales, but there was one present, and that's in maintaining medical ethics. In the case of sex selection abortion bans, there's a real concern with medical ethics. The American College of Obstetricians and Gynecologists has indicated that they believe that it is unethical to perform a sex selection abortion, except in the case of genetic abnormalities. And in addition, there's an interest in protecting the safety and well-being of citizens of the state, which I mentioned at the very beginning is one of the reasons why we have these sex selection abortion bans. But still, even if we look at those associational freedom cases, we have to look to see what the extent of the infringement is. Is it slight or is it severe? In Boy Scouts v. Dale, the court found that there was a severe infringement, and therefore the infringement was unconstitutional. But how do we look at that with respect to the abortion right? And I would propose to you that we once again go back to the place where we started, and that's Roe. Because Roe, the court in Roe talks about certain detriments that its decision was designed to overcome. Detriments that bans on abortion would impose on a woman. These detriments had to do with having to be pregnant, or having to have a child that is not wanted, having to care for a child that the family can't care for, the stigma of unwed motherhood. And if we think about sex selection abortion, these really aren't implicated in a meaningful way. It's not a case where a person doesn't want to have a child, the person doesn't want to have this child of this particular sex. It's not the case that the person doesn't want to actually parent a child, it's this particular child that's the concern. Now this is a difficult argument to make, of course, that sex selection abortion bans are constitutional pre-viability. But I hold out some hope with respect to Justice Kennedy that maybe it might be enough to convince him. Michael Paulson suggested that Justice Kennedy has a wet finger to the wind approach driven by the desire to appear moderate, by extreme sensitivity to elite public opinion, and by a concern to preserve the court's political capital and prestige. And so perhaps by offering this argument, sex selection abortion bans might be constitutional pre-viability. Thank you.
Unfortunately, we don't have our final speaker, Professor Pamela Bridgewater from American University Washington College of Law. But speakers have been very good so far in keeping to 50 minutes. That does mean that we're going to have extra time for questions. So I'd now like to throw open the floor.
Shaking your head.
You probably, maybe have facts more recent than what I've seen. But what I have read on the question you addressed suggests that in this country, when people want to have an abortion for sex or are trying to have a child of a particular sex by not necessarily abortion, but whatever means they might be using, they're usually trying to have a girl more often than trying to have a boy. It's not China, you know. So I mean, I don't know. If you might still say, well, that's a Craig versus Warren situation, but I'm not so sure I could agree with that. Anyway, so I wonder what your answer is.
Yeah, well, I mean, I think if you're looking to, if your question is about the possible harmful effects that we see in China, that the increase in, or in India probably more particularly, increase in violence and human trafficking, maybe we wouldn't have that for that very reason. And I don't know, you may know the stats better.
I'm just talking about gender discrimination, which is what I understood you to say the interest was.
Correct.
So you're saying because people tend to usually, if for some reason they have a sex preference in this country, it's more often female than male, that's discrimination against males, and therefore it meets a compelling state interest.
I think so. Yeah, I think so. I mean, I think any type of discrimination solely based on a person's sex, I think we do have an interest in that, in trying to promote a society that has respect for both sexes. So yes, even though there may not be the historical basis that we've had, certainly in the case of discrimination against women, I think from a practical standpoint, I think we have to look at the equality, the equal dignity of the sexes in general.
Just following up, one of the really interesting things to me, and since I'm around a bunch of folks who are pro-life, I maybe can get some insight into this, is the appropriation of feminist argumentation into the pro-life movement, which has been, and I'm getting a nod back there, which has been a very, there's been a strong move towards this in the last, I'd say, 15, you probably laid the ground for this much sooner because you guys are very smart and very clever. But it's been particularly clear in the last 10 years, I think, that we've seen a lot of this sort of protectionist argument, female protectionist, woman protective arguments. We saw them recognized by the court in Carhart, that abortion harms women, lies told about abortion and breast cancer, which were just not true and have been disproven again and again. Arguments made about women and mental health, which again have been, causation has been disproven, although clearly there are people who are in pain and very regretful about their abortions. There are also, and I could introduce you to some of them, people who are in pain and regretful about adoption and other outcomes of pregnancy, including having children. We see that kind of regret all over the place. So anyway, there's been this appropriation of this sort of feminist ideology and language in these arguments. And sex selective is another one of them. I think that what's going on is a lot less about concern for actual sex selection and harm against women in the U.S. caused by sex selection, because you're right, it's not a problem here in creating gendered whatever.
Ratio.
Yeah, thank you, ratio. The way it is maybe in some other countries. And certainly one way to address that, to the extent it was becoming an issue, would be to promote the value of women in communities where you felt like women were being undervalued instead. So I think that it's a really tough argument to make constitutionally, to sort of appropriate this feminist argument, but it's clearly been useful, and it in some ways for the pro-life movement. It hits some feminist bells, right? Wait, this is this is bad. So I think that they're looking for any way to pick up pockets of support, and they think this is one way to do it. And another way to do it is through the eugenics argument, for raising these issues about racial bias, which they've not been as successful with in communities of color, are not buying it. So, there were some big billboards that went up in New York saying the most dangerous place for this young girl, and it was a picture of an African-American girl, was in her mother's womb. And the community went, will not use the bad language I was going to use, but was very upset. That was what happened, and because they felt it was very offensive. So that sort of backfired. But there are attempts to use and appropriate arguments in what I think Jack Balkin calls ideological shift or ideological drift or something like this. Ways to move arguments from in a political way, very sort of concerted political efforts to do this.
Can I just make a brief comment about that? One thing I think that's interesting about that is it sounded like you're saying these arguments are totally strategic, that people don't actually believe them. There are a lot of a lot of people, a lot of Feminists for Life has been a group that's been around for decades, and I think that it's usually I think the pro-life movement is tarred as it's a bunch of old males, maybe a Protestant minister, Bible thumping, where the pro-life movement, I think, has historically been dominated by women. And in the trenches, it's women that have been the most active. The group that's most in favor of abortion rights is not women, it's men, young men. And so I think that it's not just a strategic argument. I think that that's true. That's the group that's most in favor of abortion rights are males between 18 and 30.
They're not the ones they're not the activists, let's just say, who I work with every day. So I don't know which numbers you get it from, but not that young men aren't also supportive, and for some self-interested reasons in some cases, I'm sure. So but I'm not saying that people don't believe and have strong beliefs
one thing that
about
was
it, but I
interesting
think it is a strategic
there was
move as well.
a good friend of mine, his name was Susan Smith, used to work for the National Right to Life Committee. She did a lot of media work, and she was very smart, very effective. The TV stations and some of the abortion rights advocates would not go on if she was going to be the speaker. So Faye Walton would not go on the air with her because she wanted Jack Wilkie. She didn't want Susan Smith to make the argument because you're trying to portray it as this is a male argument, a tool of male oppression. When you have somebody like Susan Smith, who was very smart and very articulate, presenting pro-life views, that didn't fit the image. And so I think that, but it reflects the fact that there are a lot of women who are been leaders in the movement. Some of them are in this room. But question.
And actually, I was going to ask Richard if you could flesh out the Ginsburg remarks a little bit more. I know you only touched on them. I'd love to hear more about what she said in 2009. Because only in my preparation for this did I realize what she said in 2012 in Chicago. So I'd love to hear.
Her comment in 2009, I quoted, was that she thought that was part of what was in the air at the time was that one of the problems with lack of access to abortion was related to a population control issue. That we had too many people of groups we didn't want to have too many of. Now, it may be she just completely misspoke. I'm not sure who the we was there. But she later said in 2012, well, I was just describing an argument that other people were making. That's not what the 2009 argument sounded like. It sounded like she was part of the we endorsing the argument. So, I mean, maybe she should have said in 2012, I didn't mean what that statement completely clearly says, and I don't believe it. I mean, I don't think that, I think what she was reflecting was this elite view that is part of the population control effort to get rid of the unfit. And I'm not saying that was her principal goal, but it kind of reflected that. So I don't think her 2012 comments, if you go look at them, didn't explain it at all. She said, I was describing what somebody else said, and that's clearly not what in 2009 she was reflecting what we thought.
And why do you think that didn't get a whole lot of discussion, I guess?
I don't know.
I haven't seen the 2009 comments and the quote from which it's taken, so what I know about Justice Ginsburg is that she's a woman who supported the right to abortion as a feminist issue, as an equality issue, starting with her work at the Women's Rights Project at the ACLU, and that she promoted equal protection views and sex discrimination views for the right to abortion in addition to liberty views, and never was part of the sort of so-called population control impetus and early stuff that came out of, in the 1920s with some of the
What she meant when she said we.
I haven't, like I said, I haven't read this quote, but what she may have been saying was, we as a movement have that history, which we liberals like to try to acknowledge and find bad things about in our movements and air them, because that's what we do. So she may have been doing that. I don't know. But,
Actually, Mary's written some stuff on that, I think.
Yeah.
Question might be
I
able
was
to.
just going to ask, sort of in the same vein, do all of you see, or what do you see the relationship as being between the eugenics movement, population control movement, and the pro-choice movement? Because that's something I'm curious about historically. And then in kind of the spirit of making you guys disagree less, I was going to ask, what if anything, what kinds of policy issues do you imagine that pro-choice and pro-life people either could or should work on together? The obvious answer being not abortion, but I imagine that contrary to what it seems today, there are other issues beyond abortion. So, if any of it. So,
I would say on the eugenics one, I think that the thing that's striking about it is that there is a denial of basic human equality. That there are, because
in the eugenics movement, or
I think in the eugenics movement, that's clearly
yes.
it. Is that it's an effort to try to improve the race, and to do that, what you have to do is get rid of the unfit. So what it reflects, and I think is a philosophy that rejects the idea of basic human equality.
But the question was, what's the relationship between a eugenics movement that I think you and I would agree
Well, what I would say is
bad
it's pretty
thing,
clear, I think, in
and
the
current
history,
pro-choice
the
movement.
history of that there's a lot of unsavory elements, and the Margaret Sanger has all kinds of racist comments.
The current
So what I'm
pro-choice
saying is that what it
movement.
reflects is a philosophy that denies the idea of basic human equality, and I think that's reflected in Blackman's opinion, that there are some people that are not persons in the whole sense. They're persons in a part sense. They're human beings. And so I think that that's what my point was, to reflect the fact that the shift to this quality of life orientation is very, very dangerous and is ultimately harmful to those of us as weakest who need protection.
Right, and I would say that the eugenics movement has no part in the current pro-choice movement and has been wholly rejected. And any historical, you know better than I do, Mary, the sort of historical roots of parts of the pro-choice movement, population control votes, etc. So I would reject that completely, and I don't see any part of it now. I think it's useful to look at all of our histories and in all of our movements to find racist elements, sexist elements, to look at ways we're treating people who are disabled in our movements and what the value of disabled life is. I think all those things are very important to do. And we do that all the time in our movements and at our private conferences. We fight about all those things too. So, but there was a second thing, which is, in the interest of bringing us together, Richard, what could we work on together? And I would start with an abortion issue, actually. And I would say, if what we want to do is reduce, there's contraception, which we can't often agree on either, can we? So we could work on contraception. But there's also abortion. If we're talking about making abortions, reducing the number of them, making them safer, because often pro-life people say they're trying to increase the safety of abortions and protect women, then we should have access to early medical abortions throughout the country, and you would reduce the number of later abortions, particularly post-viability, even though there are very few of them, but late second trimester and abortions around the viability line. If women had access, particularly funded access to medical abortion, we would be like France, and we would be like England, and we would be like Germany, where people have kind of come to terms with this stuff, and we just don't have that here. So that's one thing I would say. Let's work together on that.
I was just going to comment that I have read Justice Ginsburg's comments, and it never occurred to me that she was describing an attitude attributable to herself. I just did not read that way at all. I thought she was saying, well, at the time this was decided, this was part of the outlook. That there were people who had this attitude. I don't think she was identifying herself with that in any way. I just never read it that way.
And Richard's point of the stuff about population control was that sincerely creepy. I mean, and I guess in my own view, there were very discrete camps in the pro-choice movement at that time who didn't really like one another necessarily very well. There were people who
right to choose to have an abortion. I don't think the constitutional right should be so detailed as to say what reason you're having an abortion. I don't think there's any basis for differentiating what reason you're having an abortion. So I think women should be able to have abortions without the state interfering and asking why. That's the question, right, is can the state interfere and say, why are you having this abortion? And once you give the state the right to enter in that way and to question your reasons, you've given the state an enormous amount of power over evaluating you and your rationale. I don't think the state has any business doing. Do I think women should, do I want women to have selective abortions? Personally, I don't want women to disfavor having a female child over a male child. I would hope that people would want to have children regardless of sex. I think there are some, personally, I know there are some medical conditions that are very, very difficult and that where you end up having a child who dies after a month or two, if it's a boy in particular. And so that's one reason that women are trying to conceive girls, and then they have a certain sex-linked genetic traits that are devastating. Those situations, personally, I could understand why somebody does it, and I'm not going to condemn them for doing it. But should the state have the right to ask you why you're having the abortion? No, I don't think they should. And I think that's not the kind of state I want to live in. I want to live in a state where I get to decide with my doctor why. And the state has the power to try to encourage me to do what it thinks is the right thing in the world, which is have a child, at a good time when I can afford it, to do whatever the state thinks. The state can even say, we wish you'd have your child and not have the abortion. That the state can say that.
I'm not sure if I caught the end of your question. You're saying, would the fact that these bans are strategic, would that invalidate them?
Would that be troubling to you in any way? Would that be an invalid purpose?
I think that's part of a broader debate about kind of laws that somebody who's believes that all abortion is wrong would presumably want a constitutional amendment and think that efforts like partial birth abortion, I think that was very controversial in the pro-life movement, or these measures that are, in a sense, kind of incremental measures, I think are quite controversial. Partial birth abortion bans, it was very disputed in the pro-life movement because it doesn't actually prohibit any abortions at all. It doesn't have any impact in terms of, if you think that what you're trying to do is save lives, it doesn't have any impact because it doesn't prevent any woman from obtaining a legal abortion, just you have to use a different method. So was that a good strategy to propose laws that really had no practical impact? And I guess it sometimes depends on what day you talk to me. I think that in part what the effort there was basically an educational effort to try to bring home to people the reality of what happens in an abortion. And it's chilling to read the description of partial birth abortion in the opinion of upholding or striking down the Nebraska ban. This cold clinical evaluation of the destruction of what clearly a human being. And so I think that it's an educational effort, no practical impact. And I think that there's a place for that as well as a place for broader efforts as well.
I think really that's the best that can be hoped for from a sex selection abortion ban is an educational effort. It's really, when you come down to it, if you think about what Clark had mentioned earlier about the effect of Doe v. Bolton and the health exception, that it's really abortion on demand. A woman who wants to have an abortion for purposes of sex selection will be able to, because especially if we're looking at one of the very narrow laws, if it's solely for the purposes of solely based on the sex. A woman's going to be able to get an abortion based on sex because most likely, in all of those circumstances, she's going to have another reason for it. And even if she does not, she doesn't have to tell anybody about it. There's no requirement that she disclose her reason. So I think really the best that can be hoped for from these laws is an educational effort. It's the state speaking really in its strongest voice. The state can only speak as strongly as when it bans something. That's the most effective statement it can make. And that's really what we're getting with a sex selection abortion ban. It's the state's very strong statement about the equal dignity of women and men. And I think that's a statement that needs to be heard, and it needs to be heard over and over and over again until we get it.
I guess I want to ask, particularly Richard and Priscilla, and push back a little bit on what Mary said. I think there remains a linkage with some organizations between the population control and abortion, particularly in the international arena. When we see China sitting on the Human Rights Committee of the United Nations, when we see India proposing a China-type limitation on the number of births in that country, and international organizations do not step up and condemn them, like International Planned Parenthood, I think that it is a fair inference that there is a linkage, just as has been suggested by one of the panelists earlier. There is a fair linkage between being pro-life and having a particular view about faith and religion and its role in your life. Doesn't mean every pro-choicer thinks that China's policy is something that's politically tenable or defensible, or at least not to be interfered with. But it does mean that there are international organizations that have failed to speak out at least.
Well, I mean, as far as I know, that many international organizations, the Planned Parenthood and the groups that I've worked with have all spoken out against the one-child policy in China, if that's what you're referring to in particular, and have worked on cases of women who are seeking asylum specifically because of the one-child policies and represented those women in immigration proceedings. So, no.
International has?
No, the group I worked at, the Center for Reproductive Rights, did. And has filed amicus briefs in those cases and taken positions in those cases. So I'm not familiar with the work that Mary's done to find linkages. You know,
it's fair to say that there's still some. It's generational. I would say even within population control organizations, I would want to resist the idea that everyone in an organization like that is the same. The younger people often were more. I don't think they understood the connection to eugenics as much. They often saw themselves as environmentalists or feminists. But it's certainly true. I know that I was actually telling Priscilla earlier that within the kind of Procter and Gamble family has very creepy connections, and there's some people or organizations that were direct successors to groups like Zero Population Group incorporated that, and pro-choice people will tell you this still have a similar agenda. At the same time, that doesn't mean that everyone who's pro-choice would agree with that, or that most of them would. Or honestly, I didn't even know until recently. I thought most of those people were dead, but they're not.
Yeah, they're not.
They're not.
I see what you went for.
Right, and we have pro-choice people doing the historical research, digging up the linkages and warning people not to, get involved with people who still have those linkages. So, and we have people working in, Amnesty International working against those things, and we are working with those people. So, to then try to paint with a broad brush and use that to say that, there's a big problem in the U.S., eugenics problem in the pro-choice community, I think that's where you start to lose a lot of credibility. If you want to talk to Mary Ziegler about what's the real history, where are the ties, what's going on, okay, I buy it. If you start painting with the broad brush and that's what you guys do, then I'll go do the research and I'll, take it down one by one if I have to. But it's like things like, Justice Ginsburg is a population control person because of this statement. I don't buy it, and I'll go look it up and I'll find out. But I know I've met Justice Ginsburg, and that's not where she comes from. So
I guess
reject that.
my point there was a broader theoretical point that what is reflected in those efforts reflects this
A devaluing
of human life.
Now, if you want to say that, and then we want to talk about whether having the right to abortion devalues human life across the board, then we should be having that discussion in the country. We shouldn't be having claims about eugenics and sex selection, which are specious claims. So then we talk
And
about,
I think
is
that devaluing
there...
of human life is an important point. So you have people like Peter Singer, who makes the point that, well, you're not really a person unless you meet certain kind of quality
Right,
threshold.
and then you bring up Peter Singer, and I say...
I mean, he's not a fringe player
Well,
by any means.
he's at Princeton, and he is a fringe player in terms of the feminist movement, and he's not if you're a philosophy professor.
He's not a fringe player.
He's not a political mover and shaker. He's an
His
academic.
thinking was reflected in the recent controversy about after-birth abortion that was
he's
controversy. That's
right.
the same
He's a
kind of thinking.
philosopher, academic who pushes the limits and has nothing to do with the political pro-choice movement. But you guys always bring up Peter Singer and paint with the broad brush, and so that's how you're going to talk about him tomorrow, probably. So that's okay. But so that's how it goes. I mean, we don't talk about the real reasons. You guys want a ban on abortion. We don't, and we don't have that conversation. We have just conversations about sex selection or eugenics or something else. And the point is that the anti-choice movement has not, and now I've done it because I've jumped into calling you the anti-choice movement instead of the pro-life movement, which I was trying to be polite and do. Will not accept the Casey Compromise, will not say women have a right not to carry a pregnancy to term under any circumstances, because I think you don't value my life. You don't value the lives of women who are being forced to carry pregnancies, and you don't value the harm that pregnancy causes them. You don't value the impact on their lives. I didn't prepare that speech, but that's another one we could do.
You seem to know a lot about what about my views. I guess I would say that in one comment about Casey is I think there's kind of a misunderstanding that it's a compromise, and so you see that argument made in the literature. Priscilla Whitman at Michigan said the right to an abortion is narrowed into oblivion. There still are over 1 million legal abortions in this country every year. It's kind of it was altered the law. It altered the. I mean, that's a common claim is that Casey made a major inroad on the right to an abortion. Under Casey, a state has no power to prohibit an abortion at any time in pregnancy. So if that's a compromise, then I don't think it's much of a compromise.
One more question here from
So I'm wondering if sex selection bans are about the state making a statement against sex segregation. Can we expect pro-choice and pro-life groups to find common ground then in that area and perhaps go back to what Mary Ziegler was talking to in a time when there is a ability to reach consensus on at least those issues, and is there any movement by pro-life groups who are working on anti-discrimination, anti-sex discrimination efforts in other outlets?
I don't know. I mean, the pro-life movement tends not to focus that broadly. I mean, the pro-life movement tends to focus on the abortion issue. But are there people who are pro-life who are involved in those other things? I would suggest yes.
There are groups that I got called out on that because I published something saying the Illinois in the 70s, and I got an email saying, hey, so there's a group called All Our Lives that's an offshoot of Friends for Life. Lobbies for expansion, so people pay for women and funded contraception and family medical leave and a bunch of stuff. I mean, it's not really surprising. It's just, pro-life people otherwise not claiming commitments, which you would expect. I mean, there's no reason that all pro-life people would necessarily be conservative. They're still not like that. They're small.
And actually, coming back to the question Mary raised before about what what we could all work together on. I wonder if we can work together on post-choice. I mean, what happens when a woman decides to have a child? Why can't we all decide? Because certainly to have a child outside of marriage creates an incredibly difficult challenge both for the woman and for the child from a poverty perspective. So I think we could all agree to help women when they do make the choice to have a child, the choice that we pro-life folks want them to make and want women to make in all circumstances. But I think we can all agree to help.
One of the really difficult things, I think, is that the sort of bond between and the party politics, the party realignment that happened in bringing the pro-life folks so directly into the Republican camp has meant that anti-poverty initiatives, in particular, have been scuttled, right, in that world, or at least by the political candidates. I'm not saying there aren't small groups of pro-life people who do the right thing, who collect clothes, who do whatever. And churches, a lot of churches that do that, and Catholic Charities does some work along those lines. But the mainstream pro-life groups who have to endorse candidates who are Republicans and very anti-government benefit programs works against the ability of folks to work together on that stuff.
Of course, I guess it would be, it seems to me it might be a difference in approach. So I would tend to, so I was involved in an organization when I lived in Charlotte that helped women who were in crisis pregnancy situations and helped them not just through their maternity, but also provided aftercare to help them to also get a good start in their lives after pregnancy. And I've puzzled about why more folks on the other side of the issue don't really help in that. I mean, so that's a non-governmental way of reaching a solution. But yet, and I suspect in the case of that particular organization, pro-choice folks probably wouldn't have wanted to have been involved because of the rhetoric, because there's a lot of rhetoric around it.
And people feel accusations, at least, that there's a lot of misleading going on in the CPCs in particular, in the crisis pregnancy centers. And there may be some that don't do that, but there's certainly a lot of allegations that there are people who use deception to get women into centers and lie about, and we've prosecuted some cases like that. So there's nasty stuff on both sides where, I know of it on the pro-life side, of course, but so then you're not going to get involved with a crisis pregnancy center. And there's also accusations where they say, we'll be there for you afterwards, and then they're not there for you afterwards. So, the alignment of the pro-choice folks with the Democratic Party means we work for increases in poverty programs and benefit programs that help people actually give them benefits, food stamps, and places to live so that, they can make those choices in their lives. Certainly providing them with contraception, access to contraception, and not fighting a contraception mandate would help avoid abortion as well. So that's another disagreement.
I have about 3 minutes, and I know I've got 2 people who have questions, so if I can ask the questioners to ask the questions, I'll put both of them to the panel. Go back now.
Kind of continuing the conversation about things that both pro-life and pro-choice movement can agree on. Professor Smith, I know you mentioned that
they're so
one
cute.
of the things you believe.
We try.
One of the things you believe that people should be able to agree on is having abortions earlier so they're safer. How about moving farther ahead to abstinence education programs? It seems that would accomplish a lot of
do that anymore under our equal protection jurisprudence. So my reading of that was not so much, well, there's not just another state interest. It's that it's girls, not women. So it's another group of women, Casey treats it. It's girls, and that's different than the way we treat adults.
Yeah.
We've got a minute left. Respond in there.
You want to go? You want to do that first, since it was direct.
We can all do it simultaneously.
Okay, you go. Yeah.
Well, I think the way, so if we go back to pre-Casey to Planned Parenthood v. Danforth, the court in that case makes clear that, that rights don't just arise when a person becomes a woman. So eliminating that distinction between a woman and a girl, I mean, the constitutional right is the same. But the court in prior cases makes a point of the fact that, well, in those cases, there's an additional interest that's involved. And that seems to be what's driving the court, is this additional interest. And in addition, if you look at the way that Casey addresses these, the various different provisions of the Pennsylvania statute, it provides for its undue burden test, it provides its summary of Casey and how it's been modified, and then goes on to apply it to the various different circumstances, not suggesting that there's a different test that applies to girls and a different test that applies to adult women. And so I don't think that that necessarily fits with the way that the opinion itself is structured. So I see your point, but I'm not sure that that's consistent with my reading.
I'll just respond to the abstinence-only abstinence-only point, which is that abstinence-only education, the studies that I've seen of abstinence-only education is that abstinence should be part of a broad curriculum of sex education, because if you just teach people about abstinence and you don't teach them how to use other contraceptives, you have worse results, both in terms of unintended pregnancies, but also in terms of STDs, because people don't know how to protect themselves, and teenagers have sex. And even if you tell them, which I think is appropriate in a broad sex ed curriculum, that we don't think you're ready for that, we want you not to, abstinence is great, blah, 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 but if you do have sex, you should do this, this, and this, then you have much better effectiveness. So that's, not unpredictably, that's where I come out on abstinence.
Please thank our speakers.